Hi everyone, I'm Dale Smith, aka Journo Dale, and we're here to talk about Canadian politics. This week, I thought I'd talk a little bit about the issue of provincial jurisdiction because it's coming up a lot in the election. And by a lot, I mean a lot of the promises that parties are making are really areas that are provincial jurisdiction and not federal. So what does that all mean? The Constitution has two sections which kind of delineate where federal powers are and provincial powers are. Those are sections 91 and 92. And a lot of the things that are provincial jurisdiction involve things like healthcare, education, housing, childcare, all of these things that parties are trying to make promises around, which I think is one of those reasons why we need to take some of those promises with grains of salt. In particular, in this election, pharmacare is a big one because three of the four main parties are talking pharmacare. Dental care that the NDP is trying to push, that's also provincial jurisdiction. Childcare, which most of the parties, with the exception of the Conservatives, are trying to get some kind of programs around, also provincial jurisdiction. And the NDP are making big promises around housing, again, provincial jurisdiction, with a large municipal component. And, you know, trying to say, well, we will build 500,000 housing units is one of those things that's like, okay, but what's the mechanism for doing so? So as this election rolls around, we need to engage with the parties, whether it's the leaders or the candidates who come on the doorsteps, and basically ask them what they intend to do to implement these promises that are in provincial jurisdiction. The thing we have to remember is that the provinces are responsible for the administration of these programs, which means that they need to set up the bureaucracy and do all of the kind of background work around it and hire the people and do all of that kind of stuff. And that's easier said than done in some cases. And in some provinces, they have the challenges of their own, particularly in smaller provinces where they're already having fiscal crunches. So the notion that they are going to want to set up a new bureaucracy and have to administer it and hope that in 4 years that a new government doesn't come in and decide that they don't want to fund this anymore. That kind of leaves them on the hook to either carry the program forward in an era where subnational deficits and debt are already a problem, or they're going to have to basically tell their constituents, no, we can't keep funding this, and that creates even more problems down the road. A lot of the arguments that a party will use are that this kind of works around healthcare, so why can't it work for other things as well? Healthcare is slightly complicated, however, because while the federal government does send transfer payments to provinces to help fund healthcare, it's difficult for them to put any kind of strings attached to it. In previous iterations of governments, they've tried to negotiate accountability mechanisms with provinces for federal funding, and the provinces have basically balked and said, no way, it's our money, we're administering it, we can do what we want with it. The Liberals in 2015 had a little more success with provincial negotiations and essentially got the provinces to earmark certain federal funds for things like home care and mental health. But that is kind of a one-off basis. It's not something that is a rolling forward for any other kind of programs. Provinces will sometimes want, some kind of quid pro quo from the federal government in terms of if we're going to have to earmark these funds for our things, you might have to do something else for us kind of thing. So it's negotiation, it's not easy. It's not just, oh, the federal government can set up this program because they can't. They can fund it, but again, they're not the ones doing the administration. That can become complex with things like pharmacare, where you've got each province has their own system already in place, as well as their own provincial formularies. So trying to create a national system out of that is a bigger headache than people like to let on. So yeah, it's one of these things where we need to kind of put this information in context with what the parties are promising us. One of the other jurisdiction issues that's coming up a lot in this election is Bill 21 in Quebec, which is essentially regulating their public services under the guise of secularism, although it's not really secularism, and basically saying that public servants who are in quote-unquote positions of authority can't wear religious symbols, but it's only relegated to provincial ones. The Quebec government is trying to get federal leaders to allow them to extend that to areas of federal jurisdiction within the province, like banking and so on. And there's a certain amount of pushback from some of the leaders and not all of them. The question as to whether or not a federal government can interfere in this kind of a situation is a little more complicated than people may otherwise realize. They can join in with lawsuits around it, and that sounds like something that the Liberals are proposing they will do down the road once those lawsuits start getting rolling. They don't want to be too far ahead of that process, whereas most of the other parties have said they won't entertain any of that kind of appeal mechanism or whatnot, or joining in an appeal. But we also have to remember that when people say things like, oh, the federal government has the power of disallowance, that is not necessarily accurate. Federal disallowance powers, which haven't been used in probably a century by now, are not only basically the nuclear option and would basically be going to war with the province, but disallowance was more or less used in cases where provinces were trying to encroach on federal territory. And an example of that was when the government of Alberta was trying to print its own money during the Great Depression. That was clearly a case of intruding in federal jurisdiction, and therefore the power of disallowance was perfectly appropriate in that case. I don't know that it's necessarily appropriate in this case because it's not really something that's intruding into a federal area, even though people will say charter rights, but charter rights are actually somewhat more narrow in terms of their what they cover than people necessarily understand. And that's everything for this week. Join us again next week for some more Canadian politics. I'm Dale Smith. That's at journo_Dale on Twitter. And don't forget to like the video, share, subscribe, and support us on Patreon. Thanks, everyone.